Welcome all to this webinar on overview of India's new labor code. And I am Bilu Balakrishnan on behalf of Meenakshi Associates. Basically, law graduate and a postgraduate in HR and a qualified company secretary. As you all know, the new labor code is the talk of the town, and it brings a huge change in the labor law paradigm. It's a shift from what you already have in your cards. Many factories, establishments and entities complied for maybe years and years, and appreciate the effort of the government of India because this new labor law, when you go into deep of each code, you will appreciate that it's basically a most welcoming social legislature which will positively affect a number of workers and of course general HR and personal management aspects of every corporate, no doubt about it. So this webinar is basically a overview webinar which will speak more about the features and maybe on the outline or framework of the law. We'll be coming up with separate webinar on each code maybe in coming days, so that you can do this YouTube channel or other sources, so that we will collectively familiarize this new law. So with this background, with your permission, let me start our session. So I put this webinar's heading as Modernizing Labor Laws for a Competitive Workforce. The contents as of this webinar is taken from the Government of India press release or PAB release, so that in coming sessions we will dwell into each code very separately and very deeply. So if you look the framework of this labor code, prima facie it can be divided into four categories. Basically, you may have read about this labor law from various sources, that this rationalizes around existing 29 labor laws, and many HR professionals or IR or personal professionals, personal management professionals, of course, will already be familiar with all these laws. We have Factories Act 1948, we have Payment of Wages Act, we have Equal Remuneration Act, Industrial Dispute Act 1947, we have Employees Compensation Act 1923, we have PF Miscellaneous Provisions Act 1952, we have Gratuity Act 1972, and a number of law, Trade Union Act 1926. So there are n set of laws which you have been complying in your entity maybe for a number of years. So this code, or the codes which has been released by the government of India, basically intends to repeal all that 29 existing laws and bring it into a code format, which is now being released under the four codes, which we will look into later. So basically the intention of this release of this code is to rationalize the existing 29 labor law codes into four codes. So 29 equal to now 4 codes. So hereafter you need not want to look into the various laws which are already there. Rather you can look into only these 4 codes, which is the complete code for your labor law compliance. Next is, of course, to modernize the regulations of form filings, procedural aspects, compliances into more or less to meet the global standards. As you know, the labor force and the workforce legislations should be uniformly there for multinational companies and for the companies across the globe. So an attempt has been made to make these regulations meet the global standards to make our workforce more competitive. And the third objective of this new code is to protect the workers, while simplifying the industry. So two aspects. From workers' point of view, yes, of course, to make them more work there in protective environment. They have to be secured. They have to be protected. They have to be be in an environment where they feel very secure by the legislator too. From industry point of view, yeah, from entity point of view or company point of view, yes, they should not be put in more cumbersome compliances. So they should have an ease of doing business. So there is an attempt to have a simplified legislative environment also from industry's point of view. And coming to fourth objective is to make the workforce future ready. As you know, we all work in most modern IT environment. We work more on resilient growth aspects. You all know how capital market, how the growth of economy, GDP, everything is going in a increased number. So in that aspect, we have to be create a competitive environment, environment, and of course to meet the Atmanirbhar Bharat objective of the government of India. So to be more resilient growth country, we should have such a law, such a legislative environment where it will be most effectively achieved in every true letter and spirit. So this is the prima facie 4 category of objective of the new labor law codes issued by the government. Of this, from a compliance point of view, being a professional, and of course most of the visitors of this or the listeners of this video will be compliance professionals, especially from companies, from HR department, from personnel department. For you people, this is a very important point is, you have many laws to comply. Most of the laws were outdated, most of the law were redundant, and now you will get a fresh only 4 codes so that your compliance is being comparatively more focused and less cumbersome. Now coming to what will be the 4 codes which you all expect to comply hereafter is being categorized into 4. That's why I told 29 laws is been compiled to 4 laws, and we call it as code and not as an act. Like even income tax also they are planning to bring to repeal Income Tax Act 1961 to the direct tax code. So these codes will be the new nomenclature for the law. So here also we have 4 category of codes hereafter. One with regarding to wages. In wages we have Payment of Wages Act, right? One of the main act we already been following, and we have Equal Remuneration Act. So all these laws has now been come into one code called as Code of Wages 2019. Second category is Industrial Relations Code 2020, which primarily focus on disputes. As you all know, ID Act, that is the Industrial Dispute Act 1947, was the parent law which regulates industrial disputes, industrial harmony, and many provisions relating to retrenchment, workers, layoff, lockout, all these things. You all know industrial dispute, reference to tribunals, and all things has now been coming under the Industrial Relations Code, including the Trade Union Act 1926. So I should say this Industrial Relations Code, IRC, is now a culmination of 2 laws, that is the Industrial Dispute Act and the Trade Union Act 1926. And the third law, our third code, is relating to social security. The first 2 things was relating to the wages or relating to the employee is wages and disputes, and the second category is relating to the codes on social security, what you call as the SS. Code of Social Security 2020 is a very, very welcoming piece of law. It is a culmination, or it's a codification or rationalization of the existing PF law, the ESI law, the gratuity law, And as you know, frequently we used to refer all these law whenever an employee matters is concerned. Especially PF is, you all know, part and parcel of your salary, and also gratuity is a very very important retirement benefit which you give to the employees. So all this has been now been codified into a single code called as Code of Social Security, which comes under the category of social security legislations. And the fourth one is OSH. Now it is the very famous short form of OSH, as far as labor profession is concerned, with regarding to occupational safety, health and working conditions code. As you know, Factories Act is very important piece of legislation, 1948 law, where you were been referring for the quite long time regarding to the working conditions, safety norms, canteen facility, welfare officer, right? Working hours for women and working hours, weekly hours and overtime. All these things were dealt with the Factories Act 1948. And also regarding to occupational safety issues, you all know occupational issues like accident arising in the course of employment and out of the employment and all, regarding to the employees' compensation in 1923 Act. So that also now under been rationalized coming under this law, called the OSH law, or Occupational Safety, Health and Working Conditions Code. So this slide or this page shows the codification concept. So entire 29 labor laws has been now been grouped into 4 categories. First 2 categories related to the wages and disputes, that is Code of Wages, Industrial Relations Code, or called as IRC, and Social Security is under the another branch called as Code of Social Security Law, that is SS law, and OSH law. OSH law related to the occupational safety and health and welfare of the employees. So I think from hereafter, that is from of course 25, 26, in future also it's be very easy to remember all these laws, easy to understand all these law. Of course, the new generation HR people will be more happy, especially the new gen personal HR department people or talent acquisition people will be very happy to note that they have to learn these codes rather than to refer the year-long old redundant various legislations. Now we will look into the reforms aspect. The reforms aspect is morely on what are the main reforms which is expected from this labor legislations or labor code. So this is an overview. As I told, this webinar is basically an overview. For each code, we will have a separate or 1 or 2 video sessions, so that we will go into very detail about that. See, the basic features or systematic reforms, what we call as systemic reforms, which is been brought by this code by the government. Maybe after extensive research and taking into a lot of practical aspects, is fixing a national floor wage. So it's very important, because there are many industry, you all know, that where the minimum wages is not been properly fixed, or there are some GOs or circulars for each industries, and there are many disputes before various labor code that the minimum wages is not being paid in properly and all. So this labor codes which is in place now has been given a new concept or introduced a new concept of floor wage, so that a statutory minimum wage has to be paid to each category of workers or employees across the board. So if you don't, of course, if you don't do that, you will be a non-compliant entity as per this code. So that is one very important, maybe most, I should say, needed reform, systemic reform, which is required for quite a long time. For each industry or each sector, we had fixed now. The code prescribes now a specific floor wage. Second, if you ask me, it's the second systemic reform as far as the professionals is concerned. Maybe professionals into this, personal management domain or HR domain is concerned, is the multiple registration you have. You should have a registration for PF, you should have a registration for other ESI, And of course, even for starting an entity or IOP called as industry operations or process, you require multiple registration. Now it is become a simplified registration process and the licensing process. You will have a unified compliance system which will entitle you to reduce the administrative burden, and of course the compliance cost is concerned. So this is a very innovative step as far as I am concerned, because as far as the professional is concerned and HR professional is concerned, this is going to be a very important systemic reform. Next one is about the inspector cum facilitator model, where you all know inspections is a very important aspect of to see whether the law is being complied in true letter and spirit. The new labor code makes it mandatory to have regular inspections, and of course we should not call them as only an inspector, but they will be always be helpful for you to help you to comply with the provisions. So they will be act as not only as an inspector, but also will act as a facilitator to you to comply with the law, with of course the workers' protection or the workforce protection with priority. And now next one is they had introduced a new national occupational safety and health board to have a oversight over the entities or factories occupational safety and health measures. So again, a welcoming step. There is a nationalized, there is a centralized body or a board which is called as National OSH Board, which is the national board which focuses on occupational safety and health. So this board has been empowered with various functions and powers, which we will discuss later very detailedly, maybe in the coming sessions. So this also, from my point of view, this is a very important innovative step for the compliance of the labor law in future. And of course, I should say it's a very late legislation, because this is a very important thing which has to be implemented maybe very long time before itself. Tribunal system. You all know, earlier we have labor court, then we'll go to the tribunal, then you have a national tribunal for settlement and adjudication of the grievances or issues which is happening in the entity or especially in the factory. So now we have a new system of two-member industrial tribunal which has a timeline-based dispute settlement resolution process. So it is basically on a it is working on a timeline basis. So there is some procedures also. We will little bit look into very detail in the coming sessions. So again, faster dispute resolution system should be of course the key centric point for any legislations to be effective for this governance is concerned. So now we have an industrial tribunal system which have a two-member as a body. And coming to safety committee, as you know, especially in the case of factories, which is been in the hazardous sector, defense, production of mines, and even in of course other industries also, chemical industries and all. So now this piece of legislations, the code has now mandated some safety committees for larger establishments, where workers management safety grievance is given more importance. So as you know, safety is very important as far as this code is concerned. We have no compromise as to the safety measures is concerned. So if you ask me, these are the systemic reforms which is proposed by the new labor laws, from fixing the floor wages or the minimum wages from a centralized registration system or licensing system to the inspector cum facilitator model system, national OSH board, and of course the more effective and robust time frame fixed industrial tribunal machinery, and of course giving more importance to the safety committees in larger entities. Now coming to some core guarantees for workers' protection, and you all know workers' protection is the thumb rule of this labor code. That should be any labor legislation should look for the workers' protection. Like SEBI looks into investor protection, of course, the workers' protection should be the prerogative of any labor legislation. I hope you will agree with me. So few of the rights which has been given to or for the benefits of workers are listed below. One is universal appointment letters for documented employment, which we will again discuss a little bit later. But written terms of workers to ensure clarity. As you know, nowadays many workers, especially unorganized workers, are being employed in an entity or an establishment without any proper documentation. Especially when dispute arises, there is no proof to show that he has been employed in this organization, and there is no details about the working conditions, working hours, even the payments or the wages which has to be given and all. So there is no regulation for that. So you can employ anyone without any documentation and all. And this is an unfortunate thing, especially when disputes has been happening. So now, friends, if you see, the formal appointment letters is been mandated for workers, where there should be clarity, written clarity over the terms and conditions of the employment or engagement of workers. Next one is, as we already mentioned about the statutory minimum wages and timely payment. There is time limit for when the wages has to be paid, and you will see some rules coming on fixing up the minimum wages for each sectors where a particular employee is pertained to. Next one is mandatory social security for gig and platform workers. One of the most revolutionary changes which has been brought by this labor law code is, of course, bringing the gig and platform workers under the legislative umbrella. As you know, many aggregators, including many food serving, in fact dispatching companies, you all know that these companies will have to look into these measures very seriously, because now this law has brought into gig workers and platform workers under the mandatory social security ambit. The details, of course, we will discuss a little bit later. And the next one is about free annual checkup, health checkup for eligible workers, 40 plus years eligible workers. This is the aspect of preventive care at the cost of the qualifying staff. So this is very important aspect. As you know, many HR department, including personal department of many companies, especially factories, you conduct an annual health checkup of employees, basically on a voluntary aspect. You usually engage some hospitals or medical institutions, and you do a healthcare aspect as part of your CSR and all. But now the law has been mandating that every establishment has to conduct a mandatory free annual health checkup. Maybe there is some conditions for that, yes. So this is basically to ensure that the workers have a good health to work for this establishment, and it is morely on the preventive healthcare aspect rather than after the health issues happening. That's a different aspect. So what does it mean is the employer should ensure that the workers working under them are being health is being properly protected. So this is a very important change. Of course, it is an opportunity, a business opportunity for healthcare companies. I should accept that also, because every opportunity or every protection to workers has become an opportunity for other sectors also. If you ask me, like health checkup companies, maybe even hospitals will have a good time, because once this become mandatory, they will get a business opportunity also alongside. Next is, of course, equal pay for equal work across roles. Already there is a law called Equal Remuneration Act. So likewise, across the roles, same people to be treated alike. So you'll have an equal pay system. And next one is prohibition of gender discrimination. Yes, you all know gender discrimination is it's an issue for quite a long time, especially in various industries. Now there is a specific provisions for prohibition of gender discrimination in employment, equal treatment in hiring, equal treatment in paying, and of course equal treatment in promotion. So that is again a very important aspect from gender diversity is concerned. And coming to portability of benefits across states, benefits follow workers when moved between states. This is also another issue which you people will accept. Whenever an employee is is working in one state and he moves to another state, the transfer of these benefits like PF, ESA and all things has been having a cumbersome procedure. Now there is some provisions with regarding to portability of the benefits from one state to another state also. So this slide or this page speaks more about what are the guarantees or what are the benefits, protections which has been offered by this code, labor code, to the workers is concerned. Coming to some formalization procedures, which is again a very, if you ask me, a very important aspects of formalization of employment terms and conditions. As you will accept that whenever there is a dispute between an employer and employee, the key aspect to be looked into is the employment appointment letter. Most of the industries, most of the workers does not have an employment letter. Then how you are going to interpret that? So the now law comes with a very specific provisions for giving appointment letters, specifying the employment terms and conditions. So now the mandatory appointment letters to ensure job transparency and employment history, and clear records of roles and tenure is very important for that. So it is very clear that whenever a dispute concerns, so we can go and refer to the employment terms and conditions which has been stated in the employment letter, so that the workers' industry is being protected. And if you see, whatever we speak here in this webinar, most of the aspect is been for the protection of the workers. That should be kept in mind. And of course, not making the employer also into trouble, because employer will also get its own time to comply. The compliance will be a little bit less cumbersome also. Next one is fixed term employee receive parity with the permanent staff, equal pay, leave, medical and social security, and this is a very important aspect, especially for a government entity is concerned, government companies is concerned, because where there are more issues relating to contract employees one side and permanent employees other side. So always there is disparity as far as many aspects. Whenever you declare bonus, whenever you give leave packages or medical benefits and all, so obviously there is two policies for them. Now the fixed term employees will get the equal treatment, priority with respect to the permanent staff is concerned, with regarding to their pay, with regarding the leave, medical and social security benefits is again a welcoming step. Gratuity, you all know, one of the very important retirement benefit for the gracious work done by an employee for quite long time is the gratuity, which has been regulated under the Payment of Gratuity Act 1972 elsewhere. Now this is also been brought under the new law, where the eligibility for the fixed term employees to receive entitlement for gratuity has been reduced to 1 year. So that is very good. There were already, the law was 5-year continuous service. Now you require only 1 year continuous service to be eligible for that gratuity. That means if an employee resigns or is being removed or leave that organization after serving say 1.5 years, then you are supposed to give gratuity for that employee. You cannot take the shelter that he has not completed 5 years, because now the threshold limit has been reduced to 1 year. So that again gives more confidence to the contract employees or the permanent employees who want to leave the organization early. Next, of course, there are some provisions regarding to precautious contractualization, that is for employing the contract employees also, which discourages very short term and unstable contract employees practices followed by many companies, especially IT companies, and of course in many sectors there. So there is also some protection. And if you see, most of the provisions is employee friendly or workers friendly. So you will accept that. Social Security Code. As I told, this webinar is an overview. We will touch upon the various aspects, so that in the later webinar we will have a specific code-wise discussion. Coming to Social Security Code coverage and portability, few points I like to bring to your notice is regarding to the coverage. In 2015, the coverage was around 19%. Now in 2025, this code will be covered to around 64% of the worker community. So it is like, the coverage of this entire legislation to the workers category or the employee category will be higher end. So that means this is very important to see that the social security, legislations or the social security norms will be applicable to 64% of the employees employed in total. So that is a very important aspect to be looked into in a statistics point of view. Next one is the workers employed in gig and platform and migrant and MSME workers also covered is very, very important. You all know migrant workers work in an organization, many entities, many factories without any formal letter of appointment, without any papers, documents and all, even without an ID proof. Migrant workers, it's another issue where they work in an organization without any documentation. Now, of course, MSME, we all know we drive to promote MSMEs in all front. Here also, labor law also, now MSMEs are brought into bracket. So all the gig workers, all the platform workers, migrant workers, and MSMEs are now being covered under the employment category. So the compliance aspect is very, very, very important as far as these type of big size companies, especially factories running various factories. All these entities now have to gear up yourself to make sure that you comply with this law and cover all these types of employees under the ambit of the legislative protection, especially with regarding to the social security aspects is concerned. Next one is benefits under the code, PF, ESI, insurance and other protections. Key benefits has now been a little bit more clarity. As you know, earlier, each and everything was dealt in a different law, different registrations required, and there are many confusions where there. You all know, when you are practicing as a HR person or even the consultant or HR practitioner is concerned, now it has been made it very simple in a sense that, with more clarity. We will detailedly discuss when we discuss about each code separately. Okay. Portability, as I told, portability is very important thing. Via Aadhaar linked universal account number. So every employee, every worker will given an unified number or universal account number, which is be linked with his Aadhaar number. So it's very easy that wherever he work in India, he'll be tracked through his Aadhaar universal account number. So if he's shifting his job from one state to another state, so it's very easy to port his documents or your history of the PF, all these ESI and all to the another state also. That is again a very, very, very important aspect. And thanks that it is linked to the Aadhaar, so that the portability is comparatively very easy and more transparent. Aggregator contribution 1 to 2% with capped arrangements. See, aggregators, there are many companies work as aggregators like Zomato, like Swiggy, and there are many companies which aggregates people, pool people, and they work under them. Basically, it was little bit unregulated to be honest, but now they are coming under the ambit of many social legislations. And 1 to 2% of the aggregators has to now be spent for the social security welfare measures of these type of workers. And of course, there is some cap for this. What is the maximum amount to be spent? But again, this little bit add on to the cost to the bill of these aggregators companies is concerned. No doubt about it. But this is one part. But they will get more workers or employees to work under, because they have a social security protection for that. So this page speaks more about the social security new things, about the coverage, and of course the portability function of through Aadhaar linked universal account number is concerned. Now coming to this aspect, which is a very interesting aspect, minimum wages and timely payment. As you all know, minimum wages is the basic right of a workman, and of course timely payment is also a basic right of a workman. There are many instances, you will agree with me, in many sectors, many industry, that the minimum wage is not been adhered to. Each sector gives its own wages even for a different type of employees, workers, and even payment is also been delayed. There are many instances, labor cases going on. You all know that the timely wages has not been paid. Now the court has made it very strict that the minimum wages has to be paid for each sector, which will be specified, notified in the rules, and of course the timely timely payment. And there is a minimum, what is called as a floor price, what you call as a national floor price, price, or what you call as national floor wages is being prescribed. The statutory minimum wage for all workers, guaranteed baseline to protect the workers. So that is a very, very welcoming step. And of course, this has to be increased over a period of time on the basis of the cost of living allowance and all. That is of course the part and parcel of the interpretation. So substandard payments should be regulated. You cannot hire a worker and to pay them penny amounts. That will not work out here after in India, because we are against this practice of paying substandard payments. So we had now brought in a concept called national floor wages, that is the minimum wages which you have to pay to each sectors of the workers. Employer obligation for timely wage payment, as you may have read from many social medias, 7 days is the wage period now. For each wage period, you have to pay the wages within the prescribed time limit, and universally it is 7 days, so that the workers need not want to wait for weeks and fortnightly and all. So that now a prescribed standardized time limit has been introduced, and all these things has to be complied by every entity. Every factory is covered under this code, and this gives humongous responsibility, maybe legal responsibility rather than legal responsibility for the HR professionals across the board, across the industries, and of course for the personal managers who are working in this domain. And next one is improves workers' financial stability, dignity, less stress, and predictable household income. Yes, of course, what is the minimum wage they are receiving, and of course when it will be received, all these factors will contribute to less stress for workers in general, and of course their family will also be well protected in this regulated wage payment structure and timely wage payment structure, no doubt about it. So these are things which you may have already been known through the social medias. When we go to the wage code and all, we will specifically discuss about the nuances of each and every code. Coming to OSHWC, which is a very, very important part of this, labor code, is with regarding to the occupational safety, health and welfare. Some more aspects has been introduced from preventive healthcare point of view. So there, as we had already referred few things, there should be a free annual checkup for workers over 40 years of age and engaged in hazardous industries. It is basically preventive screening to detect occupational risk early. See, usually workers, sometimes, they occurred with some employment occupational injury, and few workers or employees in a sense take a stand that they already have a pre-existing disease and all. So hereafter there is no such disputes, because the employer should take steps to conduct an annual free medical checkup for all employees over 40 years of age, and to all workers who are engaged in hazardous industries, so that early detection of any occupational diseases, any risk for health can be early detected, so that further issues or medical dangers can be avoided. So again, a welcome step, and one side welcome step, the other side the hospitals and medical checkup entities have a good time, because they will get a lot of patients, or what you call as medical camps can be conducted, because companies has to engage some medical institutions for that. That is one side of that. Every large size company should have a safety committee. Very important, as whenever it comes to a factory, especially factories engaged in hazardous industries, including electric, electronic, e-waste, chemical industries, gaseous industries. All these industries now will have to mandatorily have safety committees, to oversee the compliance, oversee about any possibility of any hazardous accidents which may occur into this type of organizations concept. Next one is, as I already discussed about national occupational safety hazards board, or will be coming, and there is something called as occupational safety hazard standards which will be issued under this code, which has to be uniformly has to be devolved in the company entities. Many entities honestly does not have a safety policy. Many entities does not have a safety program. Now hereafter you will have to mandatorily form a national, you already have a national OSH standards, so you will also form your own safety standards in line with this national standards, so that you will have a policy in place, so that any issues or any violation of the same will be viewed seriously by the lawmaker. Next is coming to training for plantation and hazard units. You all know there are some units, some sectors where it has been unnoticed, where new technologies, new risk and issues are been evolving. So now the code has been making a step to skill development for these type of workers, so that they can handle their work with more technology and more standardized practices, so that risk can be comparatively be occupational accidents. The risk can be comparatively reduced to a greater extent. Mandatory PPE provisions and usage in plantation hazard units. Again, personal protection equipments, that is PPE, became mandatory for plantation workers and for hazard units. You all know that many workers in these sector work without any precaution, without any safety measures. So this law, this code is now making it mandatory to provide. The employer has to provide certain PPE kits to these type of category of workers, so that their health is given more priority. Risk of accidents is been reduced to a greater extent. So if you see, the code is been very comprehensive, very focused, very giving more importance to the workers' protection, and no doubt about it. As a HR professional, as a corporate law professional, as a company secretary, we should say 100% it is being a welcoming step, not only for today, for the future generation also. And the only thing, whenever I read, wherever I read about the social code, all these, I've been very sorry to say that it is very late. It's off late, because number of workers were been suffering for all these type of issues. Anyway, it is now being a piece of law. Coming to women labor reforms, this is a very important another piece of legislation, I should say, because you all know women workers has to be given more protection, more safety and equality in workspace. There were some initiatives already there in various laws, but the new piece of labor codes give more prominent importance to the safety and equality aspects for the women workers. Let's just to give you a bird's eye view of the few things. Legal ban on gender discrimination. The new law makes it transparently, prohibits any gender, discrimination, especially in employment or in the payment of wages or other amenities which you have been offering to the workers. Second one is, whenever it is an equal work for a man and woman, there should be equal wages. There is already a law, you all know the equal remuneration law is there. So make it very clear that hereafter you have to offer equal pay to the women workers and to the men workers on a parity basis. Very disputable area was the night work or night shift for workers, especially for women workers. That has been tackled here in the new law. Women workers may work night shift with written consent and mandated protection. Now they are allowed to work on night shift, but provided with the proper prior consent from the workers. And of course, you have to ensure that there are some mandatory protections for them. No instances of negative things has to be happened there. The employer has to make sure that their safety is being ensured. So again, a welcoming step. Access to previously restricted occupations with protections. Yes, there were some some sectors where women workers were not allowed to work. Now there is that cap or ban has been now been removed. The women may enter into restricted roles subject to certain mandatory safety measures. That is the responsibility of the employers. They have to provide enough safety measures to the women workers, so that they are now able to work in some prohibited sectors also, which was prohibited earlier, or restricted sectors earlier. Mandatory women representative grievance committee that is again a welcoming step. Maybe in post law, there should be the committee, there is a women representation, but now the women representation is there, mandatory for the grievance committee also, so that the women grievances can be properly been tackled by the committees which has been already in place. Expanded definition of Family dependency for benefits. Yeah, there is expansion for the definition of dependence, which we'll see when we take the piece of legislation. Again, this is again a welcoming step. Women empowerment has been kept into clear in mind by the legislator, of course with lot of protection and of course the rule of equality in place. This is a very new aspect, as I already mentioned about gig and platform workers, now been defined, now been allowed to portable services, and now they had more protection. We already touched upon few things just to have a bird's eye view. There is a clear definition about gig workers, platform workers, and aggregators like Zomato, like Swiggy. All these these type of nature of entities has now come into the bracket of aggregators. Aggregators to contribute 1 to 2% of turnover. Maybe there is some cap, of course. I think it is 4%. Mandatory employer contribution to percentage and etc. So now these types of workers has more social security protection, and the employers, that is the aggregators, now have to contribute X percentage of the turnover for workers' welfare. That is again a welcome step from, even that is welcoming for the aggregators also, because they will get more workers, and for workers also they'll get more protection. So both sides, it has been great. And of course, in the other way, aggregators have now brought into the employment, employer category. That is again a welcoming step from employer point of view also, because there was no regulation, registration, or even they are not under the legislative framework for quite long time. Now it is both advantage for the aggregators or the employers, and of course for the workers is concerned. As I already told, now every workers under the aggregators will have an Aadhaar linked universal account number, so they can be, they have an identity. So wherever they go, state, interstate, or whatever may be, their documents can be transferred, and it is been welcoming. It is one of the welcoming steps. And portable social security benefits across state, we already mentioned that it's very easy now. Wherever if you work in Karnataka and you now come to Tamil Nadu, or when you go to Mumbai, your database, your records can now be portable to the other portals. There were some doubts asked by many professionals to me regarding to portal and all. They are under the operation, and I expect that there will be a nationwide portal which will be introduced by the Ministry of Labour. I expect a very robust portal, because these all things to be implemented require a centralized portal. We may expect so. Okay. Contract and fixed term workers benefit parity, a revolutionary change for this piece of legislation is the protecting of the contract laborers. You all know there is a law called Employment Prohibition and Regulation of Contract Labor Act 1970. So now this has been brought to here, where there is a new things has been introduced, where a contract employment, that is a fixed term contract employee, is now being treated in par with the permanent staff. So that is a welcoming step, especially for, as I told, government entities. There are many entities where you have two sets of employees: permanent staff, second one is contract staff. Most of the facilities, in a way, medical facilities, leave facilities are not in parity for these type of organizations. Now you have to have a parity between these types of two categories of employees. So that is a welcoming step. So fixed term employees, FTE employees, now has to have the same wages, which is remuneration which is paid to the permanent staff. Yes, we will look into the nitty-gritties when we specifically discuss about that in a different session. But anyway, that is again a welcoming stuff. So in fact, I seen many organizations where many contract employees are demotivated because they are not treated in par with the permanent employees, with regarding to promotions, with regarding to medical benefits, with regarding to insurance also, benefits also. So now these things has to be, the HR people has to tackle it very carefully, complying with the new legislations. Gratuity is a very important change, we already discussed. Now for qualifying gratuity, you require minimum only 1 year of continuous service. So once you become 1 year qualified, you will be eligible for the gratuity for that period. So that is again a welcoming step. Most of the companies, even before this also, they give it, but this became a mandatory condition for as far as an employee is concerned. So employees who work for 1 year, 1.5 years in one company, and next year for 1.5 year another company, and change due to practical things, now they will be eligible to get gratuity for each company. Again, a welcoming step. Principal employer contribution. The principal employees must provide health and social security benefit to contract staffs. Most of the companies do, but there are many companies, entities or establishments which fail to treat contract employees as per permanent employees. Now they have to pay the price for that. They have to provide equal benefits to the contract employees also. So the morale of the contract employees, to be frank, will be elevated now, because they will be treated as at par as with the permanent employees as far as benefits is concerned. Again, for contract employee also, for eligible workers, free annual health checkup is being introduced. Welcoming step. Contract employees who are listening to the webinar, please cheer up. Good days are ahead for you. Now coming to specific sectors, as I told, now this new law has given protection for specific sectors like MSME, platform and hazardous industries. Earlier, MSME workers has their own disappointments regarding social securities. Plantation workers have their own disappointment. Hazardous industry, their own disappointment. Now, the various measures has been introduced in the new law, where specific protections has to be made to these types of employees. Few of them we will look separately. We will discuss later in very detail when we go to the separate legislations. MSME workers covered under the social security, they will also get guaranteed minimum wages. Facilities, canteens, portable water facility, restrooms are also now applicable to MSME. These benefits, and definite work hours and of course working hours and overtime rules also now will be applicable to the MSMEs. So very happy to say that MSME workers or employees working under the medium, small and micro, small and medium enterprises will have a good day ahead, because you are now under the regulated environment. You will be treated as an employee for the social securities. You will have a minimum guaranteed wages. You will have other benefits like canteens, restrooms, etc. And of course you will have a definite work period, and of course overtime benefits also. Coming to plantation workers, again an unregulated labor law where they have not been focused. They will also now get benefit under the occupational safety and health area, and they will have a mandatory training program. Welcoming step for hazardous and plantation workers. Now mandatory training program is being introduced, which is a very, very welcoming step, so that the occupational hazard accidents can be reduced to a greater extent. And of course they have now new law regarding the provision of personal protection kits or equipments. They have to be provided mandatorily by the employers. And coming to hazardous, yes, strictly safety committee is mandatory, and the compliance with national safety standards is mandatory, and of course mandatory health checkup is it is been introduced, and of course more on their health aspect has been introduced by the new set of law. Welcoming step. I should say, more happy as a HR man, more happy as a professional, focusing on compliance, because these are well-awaited legislations, all unregulated. I should say all unregulated regulations has been brought under the new labor code. Now coming to some areas regarding this overview is regarding a few things which already been discussed, but to have a nutshell view, workers' protections and employer duties, to have a nutshell view, honestly. Most of the things we already been touched upon, but few things. Like, employees in audiovisual, digital and media industry, mandatory appointment letters has been brought. That is again a welcoming step for all the, reporting channels and online digital media channels. There are some areas, I think the law has come very late, because these should not been brought, like, audiovisual, digital and ITS sectors has, everything, workers has to be now being given formal appointment letters and social security inclusions. Information technology and ITS salary released by 7th of every month, equal pay to workers and night workers, etc. We will study, we will know about this in very detail when we take, separate code. Textile and migrant workers has been brought under this legislation. Mine and dock workers has given formal recognition, ESI coverage and safety standards and all. Again, for workers' benefit also, written appointment letter. For employer concerned, they have to issue for all HR people. Please be very careful. Please start drafting formats that you have to issue, appointment letters for every type of workers, fixing their, mentioning the terms and conditions very carefully after taking legal opinion, of course, to have an expert opinion also, because this should not backfire you on any aspect at a later point of time. Salary is to be released by 7th. Again, as far as employer is concerned, make sure that you release the salary by 7th. So this slide speaks about what is the benefit for a worker and what the employer should do. Okay. And all this, I think you can just go through this, beautiful comparison. Formal work status should be given to all type of workers. ESI benefit, health coverage is required, and safety measures has to be ensured for every category of workers. As far as employer is concerned, they have to recognize workers hereafter. You should not have any worker in your organization which is unidentified. Specifically say who is that worker. What is the category of that worker? What is the minimum wage for that worker? Where is the appointment letter? Everything you have to make it crystal clear, transparent and documented. Okay. Ultimately, workers can access to gratuity, provident fund, statutorily all the database or documents, and the employer side, of course, make sure that all these changes, 1 year gratuity, PF, and of course enforcement of entire this labor law code has to be made compliant within the well time limit. So this slide basically speaks about what are the key changes, what are the benefits that the workers get, and what are the action to be taken by the employer. As I told, in separate webinar for each code, we will discuss about the action plans, action points which we have to take into account. Okay. Compliance point of view, as I told, now multiple registration licensing complexities is an old story. Now you will get a specified, simplified, centralized system. So there were multiple filings with various authorities, with various regulators. There were higher applicability limit, like threshold limits for multiple laws. There were benefits for regulators, streamlined oversight. There were regulators also need to do inspections in different type of legislations. Now for them also it is now advantage. Now what we will get after this, you will have a pan-India single registration, licensing form, one return and compliance and reduced duplication. So I expect a very robust website or portal to be issued, to be launched soon by the Ministry of Labour, where every you can have a registration for multiple aspects, for PF, for ESI, for everything in the single click buttons, and you will generate a all India PAN basis registration, all India basis PAN registration, right? And of course, for employees, your compliance cost is less, your time is not being wasted on the various portal, paperwork will be reduced. So we are going to see a very important change over the compliance scenario of this the labor legislations. I'll come with a separate video when rules is there with some demonstration or live demo on the website. We will come with that. So at that point of time, we'll elaborately discuss about that. But this page speaks about the sea changing in labor compliance aspect. And this is very good for practitioner labor law advocates or lawyers also, or for practicing company secretaries also, because this is another scope where we can assist companies to simplify the procedures, transition from the earlier platform to the new platform, and what are the areas where you have to change, and all these things will come out with a separate video, and of course it will be very useful for you, especially if you are in the HR domain. So like for example, MCA for corporate compliances or company compliance. Now there is only one portal. Everything is been centralized. For income tax, there is only income tax one portal. Everything is been centralized. Likewise, now every entity will have a single registration process, a single pan India registration, one registration number. Log in into that. Everything can be done in that portal. I proposed, I proposed that, that should be the way, not on multiple portals, of course. And of course, compliance cost will be reduced, headaches, all the fees, administrative expenses across various authorities will now be centralized. For every law, there should be a very good, dispute resolution process. You will agree with me. In the new piece of labor codes also, we have a very simplified, faster, transparent dispute resolution with a clear governance norms. We have conciliation process where you all know if most of the disputes can be settled through conciliation. If it is not, then it can be moved through a resolution process with the intervention of the tribunal system. As I already mentioned, 2-member tribunals is coming. And next you have the national board, which is the centralized board to harmonize the standards and which will oversight across all the tribunals and inspectors and facilitators. So this is a very important takeaway. The administrative mechanism of the labor code is vested in 3 parts: conciliation part, the resolution part, and of course the national board part. Again, these areas we require a lot of clarifications from rules, procedures and all. Whenever it is released, we will come with a webinar video so that we can assist you to, acquaint with all these things of procedures is concerned. But I guarantee you that it will be very simple, direct, and it will be a robust system, because the government is very keen about to make the entire labor law compliance as part of the ease of doing business. But at the same time, not at the cost of compromising the workers' protection. I hope you got the point. 2-member tribunal and inspector. So this is very interesting. Inspector as a facilitator, not only to put you on inspection and to charge you fine, but they will be a facilitator for you. They will help you. They will guide you as to how you can be more compliant entity. So a sea change from a fine charging or dangerous, what usually when there is some inspection, we used to look in a negative way. No, now they are acting as a facilitator to you. They will guide you. They will help you to comply. Okay, so it's going to be a sea change in the administrative reforms also. This is my judgment. Mostly this will be the how you have to implement the same. 21st November 2025 is the date where the code come into force. Maybe by Q4, that is the next quarter, we will see a lot of engagements with the stakeholders, public engagements, lot of seminars, webinars, classes, like what we do now. There will be a lot of interactions with the stakeholders. Maybe from next quarter, that will next financial year, April, first quarter, the rules will come into place, and the drafting of all the rule-based standards will be there. And by 2000, the phased implementation will be happening. So this is my idea about how this labor code will be implemented across the board, because it cannot be implemented by a switch level, right? Because there are many things has to be changed, many new norms has to be made. And one of the main point is many HR department or many entities established have their own ERP, their own platforms, online or offline web-based platforms, or what you call as ERP platforms. So many changes has to be brought into there. Like for example, the computation of the basic pay, you all know 50% calculation is there. 7th day you have to pay these wages. For gratuity computation you have to do that, and that 50% is very important. All social media talk about the total out of the total salary, the basic pay, the basic pay and the DA, and should not be more than 50%. All these things you have to design. So this is my roadmap, which I believe to already 21st November the law has been notified. Maybe the last quarter, that is the last quarter of 2025 will be the engagement phase, where you all learn, you all be equipped, and the first quarter of 2026 the rules will come, so that implementation stage will start, and in a phased manner it will be implemented. So this is my view, not a legal things. Expected change is, of course, social security coverage. From 2015 to 2025, you will see a sea change over how the social security reforms is be happening. Next is, of course, projected increase in the social security coverage will be very high, and you will see the compliance cost, compliance complexities will be reduced to a great extent, and tribunal speed, tribunal's transparent, timely disposal of disputes will be on a higher rate, right? And this will, of course, make more formalized employment, more inclusion of gains for the workers. And in many factories or many sectors, you will see there will be always a percentage of people who are unformalized, and only X% will be formalized employees. They are not on the roll. They are not on the roll. There is somebody in the roll, somebody not on the roll. There is no such concept hereafter. Every category of employment, workers, employees will be formalized employees. So that is going to be a expected outcome. And of course, work safety and preventive healthcare due to the preventive healthcare checkup and all these social measures which we discussed. We are going to see a corporate Inc. in a different concept. And of course, macro impact and employment skilling, and of course the employment aspects, employment sector will hereafter be in a different aspect. Most of the employees, workers, will be more happy to get all these benefit. One side, on the other side, employers has to gear up to comply with all this law. You have to treat this law not as a burden, not as a cumbersome procedure, rather than an opportunity to serve your employees in true letter and spirit, create a new India environment in an employment culture is concerned. And yes, again, there is, rule making is pending there. Timelines for registration is to be expected. Universal account number has to be rolled out. These are things which you are expecting soon. So prepare, sector-wise, standards, issue guidance and grievance committees. So there are many regulatory actions pending which we wait for rollout. Basically, as I told, we require a portal for that. We require, single registration concepts, how to register, when to register, all the formalities and all. And of course, universal account number creating is very important for employee. There should be an account number and all. So we will take some time to come into that. These are the action points for the regulators is concerned. So with this, we complete an hour of overview of the labor code. I hope you gained some knowledge, and we will come out with specific topic-wise webinars very soon, especially with regard to each code, like wage code for wages, for disputes, industrial relations code, for OSH separate session, and of course for every aspect of security legislations we will come separately a webinar. For any webinar or for seminar or workshop or advice services, you may please contact, so that we will have a collective, we'll take collective effort to make this law purely implemented in true letter and spirit, make the working environment more safe, make the working environment more healthy, and of course ultimately workers protection and employee protection should be the more focused agenda for all HR people. Thank you. Bilu Balakrishnan signing off. See you with another video.